we're gonna have a little bit of a problem. This groom is going through the canyon, the Beck Canyon, and so she said she was gonna be a little delayed. She needed about 5 minutes.
Okay.
Arguably, we could deal with Mr. Carver's part of it first.
Okay, let's do that. Thank you. So the court will call 23 JV 53, people in the interest of Austin Apollo, Artemis, and we have Ms. Shaver here on behalf of the department with Ms. Murillo. I think she is online as the case manager.
And this is Mr. Elder.
Oh, very
His
good.
attorney was here, but he had to go get a protection order.
Ms. Osborne in the courtroom, very good, and Ms. Groom is in the canyon on WebEx. So we certainly won't address your case portion, Ms. Alford, until she is back with us. Then Austin Elder is present, thank you, and your attorney, Mr. Hawley, is not present, but it sounds like we're not doing anything with respect to your case today with Elder. Okay. And then Hunter Carver, is he present? No. And we have Ms. Fulmer on behalf of Mr. Carver. And then the guardian ad litem, Ms. Coleman, is appearing via WebEx. And I don't think we have a CASA present yet. And then, so we are set for a dispositional hearing regarding Ms. Alford as well as Mr. Carver. And so it makes sense to go to Mr. Carver's portion first, since Ms. Fulmer is with us. And Ms. Fulmer, do you have any objections to the disposition order?
Yeah, Judge, first I'd like to just put on the record that previously my office has attempted to get Mr. Carver to his hearings. He is currently incarcerated in the McConnell prison in Texas. We actually got a writ signed by Judge Larson to get him to the adjudicatory trial. And then the Texas jail refused to honor that writ. They said they did not have WebEx, and they said they would not call in via WebEx, and they would not get him there. And so he, as a result of being in the Texas prison, will not be available at any of these hearings. I do communicate with him via Securus. My paralegal did send him a copy of the treatment plan via Securus, but we have not heard back, so I'd ask to set this over.
Any objections?
Your Honor, I do object. I think we could go forward on it. I don't see that there's a lot more we can add to the treatment plan. Obviously, if Ms. Fulmer at a later date finds more information or more classes that could be available for her client, then we can certainly add things to the treatment plan. I don't know if Ms. Murillo has been in contact with this case manager. Sometimes, as the court may be aware, it is very difficult to get a hold of case managers, and certainly we're dealing with a different state. While we still have obligations to provide services and make sure that father can hopefully have some contact with his kid, with Austin, it becomes very difficult given that he is in a different prison system. They don't have to abide by Colorado law.
I do note the child's age is 6, and this case has been pending since May.
And Judge, I would object to going forward without Mr. Carver's position on any part of the treatment plan, and certainly without the opportunity to speak with him about his wishes. He is entitled to representation at each stage of this case, and that representation includes stating his position, which I have not been able to obtain through no fault of Mr. Carver's.
Alright, I know Mr. Carver's adjudication entered October 25th. The court is required in an expedited situation to set the, have a dispositional order, within 30 days after adjudication. So I will ask Ms. Coleman what her position is.
I oppose a continuance. It is an EPP case. The other two children of this case are much younger. So I would agree with the department that we need to have a dispo order entered and a treatment plan entered. And if later we need to modify it, that's certainly an option.
Owner's objections for the record, but at this time, the court is not going to cause to continue this. And so the court, if Ms. Fulmer has no objections to the treatment plan today as it is, the court will find that it, and does find that it is, appropriate for reunification in that, for the reunification purposes and, the fact that this is an expedited case, the court finds it's important to move forward in that,
And Judge, I would just like to correct the record that it's not that I don't have any objections. My position is that I can't take a position because I have not had the opportunity to speak with my client about it.
I understand that, you made that record, so, okay, if you're not willing to be collaborative and point out issues with the treatment plan today, or on behalf of your client, then, I'll adopt this plan, since you haven't spoken with him, and
if I could make further record, I will let the court know, I know the last portion of the treatment plan is housing. Mr. Carver, it's my understanding, is incarcerated, I think, until 2026, if I remember. I think that housing piece is going to be very difficult, obviously, for him to achieve. At this point in time, I think it probably would be appropriate for us to remove that provision of the treatment plan with the intent that if he is released, we'll then add some portion of that. I know that we are doing home studies for this child with family in Texas. I don't know where we are in that process, and ICPC has been sent out.
okay. If you're striking objective 5, housing and employment, the court will do so, but I do see that these provisions were already conditioned upon release from custody, so
We can just leave it in then.
and, okay. Then moving on, I see Ms. Groom is now present. Ms. Groom, do your client have any objections to the proposed treatment plan?
Yes, Your Honor. Regarding any kind of substance abuse treatment or evaluation, she would object to that. I don't think that we've had anything in this case that shows that she's consistently, or this case open because she was consistently using any type of substance. She does object to the random UAs and a co-occurring that would include a substance abuse evaluation. And she does have concerns, but she did do UAs, and every UA that she has done in this case has been clean. Also, the concern is that she had some releases that she is very concerned about the signatures on the releases. She does not recall making those initials on those releases, and we're investigating that right now, so she's very concerned about that piece. Also, the portion which is objective for, I believe, she also is very concerned about and does not agree to take a mental health evaluation at this time, because she did just recently in 2021 took a full psychological evaluation that did not diagnose with any mental health issues. She would like to continue to work with her therapist on PTSD, because she was a significant, victim of domestic violence. And we do need to make sure that she's getting the treatment for that. She did, have some requests. She would like to add such thing as life skills to assist her with, the home, to organize and get some skills to assist getting rid of things of her perpetrator, and get more organized in that aspect. She also would request that, there could be an individual, that a caseworker that she works with would be specifically trained in trauma-informed practices, and working with domestic violence, impacted families. There were some severe situations that she was a victim of, and we just really need to know that the person that she's working with can address those situations and know how to work with an individual that has gone through so much. So, if we could look into that situation. She also would like to be connected to some, community supports, an individual in domestic violence, an advocate to assist her during her FEMs. See if we can get some supports from the community under domestic violence or something, an advocate. That way, I believe those are the ones that she has addressed with me. I don't believe there's anything else, but she does have some significant concerns with this case, and how it's been handled. So she wants to make sure that she makes a record, regarding those issues. And she may want to say some more, Your Honor. I just want to make sure that if I missed, anything besides objective 4, that she be able to speak on that too.
Well, I didn't hear a specific, I didn't hear any specifics as to why she believes this case has been mishandled. So I think just making statements like that isn't helpful to the court or the parties or anyone in moving forward with reunification. So if you'd like to make that record now, that's more helpful, but just in throwing out inflammatory language like that is not. Anyway.
And Your Honor, I don't think that it's just throwing out language. She's had concerns from the very beginning that she's expressed. Like I said, the releases that were provided, she does not recall ever signing those. So she's concerned about where those signatures came from. So that's one piece. And it's really important that we have somebody that is trained in the.
Okay, with regard to the ROI, is your client revoking her previous ROIs then? Is that what you're saying?
Your Honor, we're trying to figure out who signed those.
Well, either she has valid ROIs right now or she doesn't, Ms. Groom. I understand you're gonna investigate, but if...
Right, it seems like I think what you're trying to get at is it seems like it would be the easiest if we just have her sign a new ROI. I don't know if Ms. Murillo can address if she's done that already, but obviously that would be for services going forward.
And that's what the treatment plan says, I believe, is that she will sign necessary releases.
Right.
I'm not talking about the releases that she'll be requested to sign. It's the ones that she was concerned about in the past. That's something that we're looking into. There's nothing to revoke right now. I think going forward for the services to be put in place, she would have to sign releases. I don't believe those releases have been signed, provided.
Well, we will get new releases signed, and I think we will consider the old ones revoked based upon your statements. But those new ones will need to be signed in a very timely manner in order for us to continue services such as parenting time.
Absolutely. All right.
Well, she did. I do know she had signed releases for parenting time. I think that was one of the things because she wouldn't be having parenting.
Ms. Grimm, thank you. You just can't generally say we have issues with this. It's very vague what you're saying.
I said that the issues were with the UAs, the releases that were signed for the UAs, not the releases with her parenting time. She has been having parenting time. She did agree to sign releases, and she did sign releases. The ones for the UAs is what she's concerned about.
Okay.
Thank you for that clarification. Ms. Alford, did you wish to say anything?
I do, Your Honor. I do have, the revised statutes, Title 19, Article 3, violations from the very beginning, listed exactly which ones that they are. I also have the ROI which Robin Weisgerber, the supervisor at NCDHS, sent to me, and I've highlighted every single, forged initials in the case, and then I also have a verbatim quote from Stephanie Murillo saying, regarding the ROIs and her testimony during the trial, saying, I attempted to, but she did not want to provide me any information, and she did not sign any releases of information for us to get any information
Okay,
about any providers, therapists, or services for her children. And the only way that I've obtained any of
Okay,
this
Ms. Alford,
information.
please stop. That's not what we're here for today. What I'm here for today is your treatment plan.
Right,
If
okay.
you have any information, to provide the court in addition to what your attorney has provided with respect to any of the proposed, treatment plan requirements, that's what I'm here for today.
Yes, so the treatment plan requirements, between me and Austin Elder are very, very different. He is not required to do half of the things that I'm going to be required to do, and the things that I'm going to be required to do are unsubstantiated for the reasons backing them. And this is very lopsided of a case. It has been lopsided from the beginning, and that's why I wanted to bring up the statutory violations that this case has.
If you feel that, then you need to talk to your attorney and she can file a motion. We're not here for that today. So I'm not, other than I understand you disagree with how this case has been managed and you disagree with the case. Do you have anything else with respect specifically to the treatment plan?
Yes, with respect to the treatment plan, I would like the ADA, so like the Americans with Disabilities Act, because I have PTSD from the egregious domestic violence that I've experienced at the hands of Mr. Elder. And so I have some recommendations for some accommodations that can be implemented in my treatment plan.
Great, can you provide those to, it seems
Yes.
like providing those to either your attorney or Ms. Shaver would be helpful. I don't know.
And those are the things that I stated earlier. The trauma focused, the caseworker specialized in trauma focused, trauma and those three things that I mentioned. A life skills worker to assist her with cleaning the house out and getting the perpetrators things out, and the advocate in the community. Those were the three things that I had mentioned earlier. Those are the accommodations that she was request.
Okay. Is there anything else on your list?
Yes, so with regards to Mr. Elder's treatment plan, and mine having so much more criteria for me to meet, so many goalposts for me to meet versus him, I'd like my treatment plan to reflect his in terms of, how rigorous it needs to be. Because I actually have visible and tangible evidence of Mr. Elder abusing the children. Nobody has had any evidence of me abusing my children, neglecting my children. There's no adverse effect on my children, and yet he's been given a cakewalk. And my proposed treatment plan looks like just excessive.
Well, I'm not here about Mr. Elder's treatment plan today in the court. The requirements for issuing a treatment plan have to be reasonably narrowly tailored and appropriate for the reunification of each of the family and an individual parent with the children. So whatever his plan is has no bearing on what the court's going to order for you. So, is there anything else you wanted to make a record on? Any other issues?
Yes, but I don't feel like it's going to be heard at this time. I'll just bring it up with my attorney.
What I will note, Ms. Alford, is you did not fill out the family social history. That would be helpful to provide all this information. I think, it's very difficult, Ms. Groom, for, everyone to be ambushed at a dispositional hearing as to all of these changes and requests, and we're not here to just, point fingers at other parties or other parents or anyone. We're here about a treatment plan that's appropriate and necessary for reunification of the parent with the children. And that's the court's focus. So with respect to, and it's clear that this case is so contentious at this point that hopefully parties will move past. Ma'am, Ms. Alford, what I'm concerned about is these children have been out of the home since May. And we're just now getting to a dispositional hearing, and this is an expedited case. You only have a year from May to get your children back, and so you certainly have Ms. Groom to fight for you, okay? But in the meantime, there needs to be some way that you and the department can work for the interest of these children so that you can have them returned to you. That is the goal of this case. And I'm just concerned, based on everything I'm hearing today, the parties are not working to, toward that reunification, that there are a lot of, continued, contentiousness over things that don't have to do with the children. So, Ms. Shaver, what is your response to the,
Right, and we're certainly not gonna be objecting to life skills. I don't know if, I'm assuming Ms. Murillo has had some training in trauma informed based upon the fact that DHS does a lot of that type of training. And certainly she can address that. As to an advocate from the community for domestic violence, I don't know if there is an individual that can come in for FEMs and be that support that Ms. Alford is asking for, but certainly it is something we can look into, understanding that she does have trauma from domestic violence. So we're not going to object to adding life skills, and again, we will look into that domestic violence advocate for her. As to the issue of the mental health and substance abuse, I do note that we're asking for capacity to parents. I know that there will be a complete evaluation, psychological evaluation, and probably an update done for that as well. So I do ask that we leave at least the UA portion, UA hair follicle portion on, so that if we do have concerns, we can request those. I do appreciate that she has had clean UAs since the beginning of the case. But I do note that there were some things in the home at the time that the children were removed that made us believe she at least was using marijuana. I believe that there was testimony by Mr. Elder that there was a history of meth use. I don't know if there was, but because clearly our UAs now reflect that there is not that at this time. I can tell the court, and I don't know if Ms. Groom is aware of this, they won't do just a mental health assessment or a substance abuse assessment. It has to be that co-occurring piece. So that would be required if the court believes it's appropriate. But I would be okay with removing that because we're doing the mental health portion in that capacity to parents. And I think Ms. Coleman may have additional additions.
Well, I just want to throw this out real quick before I hear from Ms. Coleman. The court's concern is, I know a capacity parent evaluation is timely. It will take a long time before results get back, and before, if treatment is being recommended, that mom or whoever can get into treatment. So a co-occurring is helpful to get services
Started.
And I started and quicker. I did hear that Ms. Alford has a therapist right now, and I heard that there was a 2021 psych eval completed by Ms. Alford. has, it would probably be helpful if there was more collaboration and Ms. Groom was able to show that psych evaluation to the department or figure out some way, for the department to speak with her current therapist. But at this time, it does appear, based on all the information the court has, that would be an appropriate service. So, and Ms. Alford, please put your hand down. And then Ms. Coleman, what are your positions?
I would agree with DHS basically in what Ms. Schaefer just said. I strenuously object to removing any requirement for UA testing. There was evidence at the trial, and there's some indication otherwise before this that substance use, including methamphetamines, is an issue. The oldest child's been removed twice now, and so I think we need to deal with all the issues here and not just kind of patch stuff up and wait for it to happen again. So I think addressing the substance use is imperative in this case. That's really all I had to add.
And do you have a position on whether a co-occurring assessment should be required, or is the capacity to parent evaluation sufficient?
I would think the capacity to parent would be sufficient, but I also understand what the court just said, that having the co-occurring evaluation first may actually help us get some services in place before the PCE. So I think it'd be useful.
Okay, and so, Ms. Groom, any responses to what has been said?
Well, Your Honor, we would just maintain our position as we had stated earlier. I still believe that she's presented and she's willing to provide the psychological evaluation. And again, I think the UAs she's taken so far have been all clean, so I don't know why there's a need. There's been nothing in this case that's proved she's currently using methamphetamines.
Okay, so, the court, having heard everyone's positions, will, adopt mother's recommendation and request for a life skills service to assist her with the home and removing items from her domestic violence abuser. At this time, the court's understanding is that all of the caseworkers should be trained in trauma-informed practices, so I haven't heard how specifically this is not being accomplished today, so I'm not going to order it, or I guess I could order it and she gets the bill, but I don't know exactly what the request is. Extremely vague. So I'm not going to order a caseworker specifically trained in trauma at this time. Then, because everyone seems to agree the capacity parent evaluation is enough, the court will strike A of objective 4 and not require the co-occurring. And I have to say, I know that Ms. Alford, according to her attorney, is in individual therapy at this time, so hopefully that will be helpful. And then, so since she's not doing the co-occurring, I think I have to strike B as well. But at this time, based on what the court read in the family social history, as well as representations by counsel about the testimony and evidence at trial, the court will leave the requirement that, there be random delays at this time. And then,
Are we taking out the other portion of objective 4 then? Or do you want to leave all of it in?
I'm taking out A and B of action steps,
Thank you.
and then A for the measurements of success. I think B still applies if she's in her own individual therapy. And C still applies. Don't know if D does. I'll strike D. Then, with regard to having a domestic violence advocate to attend and advocate for her in FEMs, the court is aware that any parent can bring along with them a support of their choosing. I note that Ms. Alford has an attorney who can also attend an FEM. I also know Respondent Parent Council has access to social workers themselves. I've never heard of a DV advocate to represent the mother's interests in FEMs or advocate for her. I am not aware that that is something that can be provided. And based on what the court has already indicated, the court does not find that it is necessary to add that to the treatment plan. I think I've addressed everything. Ms. Groom raised the ROI issue, but that really didn't have a bearing on the court-ordered treatment plan. Okay. So the court finds that the treatment plan for mother, given the modifications the court has made, is reasonably calculated to address the reasons that the children were brought into the Department of Human Services care and custody and are necessary for the reunification of the children with a family member. And so, all right, do we have a review set already?
It sure seems to me we should.
There's one in February, on February 6th. It seems a little bit out, but I'm nervous that people are not gonna be, working together, but, okay, we're adjourned then.
Thank you.
Oh, perfect. Oh, you're fine.
Thanks, sir.
And then the court will call Kathy McCabe and Elisa Root, 17 DR 30227.
Thank you. Nice to see you. We are now on the record in 23C 1226. Lauren McGee v. Vicki Alford. I have Ms. McGee, present person, pro se. I have Ms. Alford, present person, pro se as well. We are here this morning with respect to a return on service. Ms. McGee, I do not see in our file that service has been effectuated. Have you been able to get service yet? Have you been able to have the protection order served on Ms. Alford yet?
I gave it to the sheriff's office and they were gonna do 3 attempts.
Okay.
I haven't heard back if it was successful.
Ms. Alford, you're here. How do you know about being here?
I check the court docket often.
Okay, have you been provided a copy of the protection order?
I have not.
Okay. Got a couple of options then. If you are willing to waive service, then we can go ahead and move forward with the proceeding. If you're not, then we'll set a future court date and see what happens.
I'm not sure. As you know, I tried to get a restraining order as well last week, and it was denied because I didn't have an imminent danger to my life. I'm confused as to what Ms. McGee thinks is an imminent danger to her life. On my heart, I'm not a violent person. So I do have a ton of evidence to support my theory as to why she's doing this. I'm not sure exactly why Ms. McGee is trying to do this. I have not contacted her. I haven't harassed her. I have not attempted to be in her life at all. So I feel like we should do this today.
Okay. So what I'm understanding is that you're willing to waive service in this instance.
Yes.
Can you get an extra copy of that for me so that we can get it here real quick? All right, let's move to the next step of it then. Ms. McKee, are you seeking for the protection order to be made permanent?
Yes, I am.
And based on what I think I just heard, I understand, Ms. Alford, you would like to contest that and have it set for a hearing?
Absolutely.
Let me find the date and time for us.
Yes.
Monday, November 27th, at 9:30 a.m. for a hearing on whether the protection order should be made permanent. Then, if you give us 1 second, we'll get to this protection order, and then we all copy it also. Additional questions I can try to answer for everybody. Ms. Alford, you are advised the protection order does remain in effect for the time period between now and when we come back. Any violation of the protection order is a criminal offense. Ms. McGee will allow you to leave first, and if you're the protected party, Ms. Alford, if you'll just have a seat in the gallery, give her a minute or two.
If she were to make contact.
Procedural, so I'm comfortable answering that. Standard proof is twofold. First is, has some act occurred which would give rise to the issuance of a protection order? Second question is, unless restrained, will said acts continue to occur, or alternatively, will acts designed to intimidate or retaliate against the protected party continue to occur? The standard that I apply in answering those two questions is what's called proof by preponderance of the evidence. Put differently, is it more likely than not that both of those factors are fulfilled? At the end of the hearing, the answer to both questions ends up being yes, protection order would be made permanent. If at the end of the hearing, the answer to either question is no, protection order would be dismissed. And so, shortly,
that some act has occurred that would give rise to the issuance of a protection order. If you think back to the form that you filled out, those check boxes that were on the first page, and then 2, unless restrained, will that continue to happen?
Okay, so for ponderance of the evidence, if she were to allege that I called her or showed up anywhere that she was, or tried to harass her in any way, shape, or form, what's the standard of proof for that? Like, you know what I mean? Like, if she were to just call 911 and say, oh, she's here at my house, and have no evidence for that.
I would provide the exact same answer that I just
Okay.
gave, because outside of that, I feel like that's too
For ponderance.
detailed of a question, and then
Yes.
gets into an ex parte communication, which
Right.
I'm trying to avoid.
Okay.